It can be, and so what happens is sometimes one party or both of them want to terminate marital status and they haven't yet resolved any of the financial issues. If 6 months has elapsed since the court obtained jurisdiction over the respondent, which would normally be when they're physically served with a petition for dissolution of marriage, after 6 months you can ask the court to terminate marital status, and if the parties agree, the court will terminate marital status after 6 months. And conceivably, it could be years before the other issues are resolved, or sometimes the other issues are resolved before marital status terminates. So there isn't necessarily any order in which issues have to be resolved.
Okay. So how does the court determine whether a spouse or former spouse qualifies for spousal support?
Okay. Well, again, looking at temporary support, it's a little bit easier. The court can look at that information, put it into the computer program, push the button and say, here's the answer. In the area of permanent or judgment support, it's a little more complicated. First, the law says the court can't just use a computerized program and use a mathematical formula for calculating spousal support. They can look at that program and see what it says, but they can't just use that to set support. There's a family code section that tells us that the court must address certain factors, starting with the age of the parties. How old are they? Is there a disparity in age? The health of the parties. Certainly if one party is very healthy and the other has significant medical issues, that might have a bearing on the amount and duration of spousal support. The length of the marriage is a very significant factor the court has to address. The law tells us that a 10-year marriage is presumed to be a long marriage, and after a long marriage, the court is not supposed to set an absolute termination date for spousal support unless there's clear evidence that the supported spouse will be self-supporting by the time the court sets for termination. So, if you're married significantly less than 10 years, you might expect your support order to have a finite duration as opposed to a marriage of over 10 years, or certainly a very long marriage, 20 years. It's nowhere near as likely you're going to have an absolute termination date, at least in your initial judgment. The court has to look at standard of living during the marriage, and that's very important because that sets somewhat of a ceiling on how high spousal support can go. You may have, your high earner may be on an upward trajectory in their career and having their incomes continuing to increase, but the separation occurs back here. Well, that standard of living established during the marriage, we usually look at the last 2, 3, 5 years of the marriage to determine that standard, somewhat sets the stage for future modification. So in the future, if there are disputes about modification or request to terminate support, the court has some basis to see, well, what was the standard here, and perhaps how much support might be too much for the recipient. I think whether somebody stayed out of the workforce to raise minor children during the marriage is a factor the court needs to consider. They also need to consider how much property or debt is each party going to have after the dissolution. One party may have separate property. They may have had an inheritance or property from before marriage. They may own a separate business. That's a factor the court has to look at and see if there's a disparity there. I think I know there's a catch-all. Anything else the court thinks is relevant, they can look at too. I think I covered most of the factors. So the court has to really look at all of these and kind of throw them together and then come up with an amount and duration of judgment support. And this is an area where, if you're following this, there could be a lot of discretion. So different judges looking at the same factors might come up with different answers in both the amount and duration of support.
Okay. So I think you sort of talked around amount, particularly as far as maintaining a standard that you had during your marriage. So why don't we talk a little bit about duration? How does the duration of the spousal support determine? I guess that's how long it's paid out. So.
Yes. Well, first, after a long marriage, a
so
common,
over 10 years.
Yeah, over 10 years. So say you've got a 15-year marriage, and a huge disparity in earnings. Maybe you had a spouse that never worked and the other one's a high earner.
Right.
You would expect that the court order would say that spousal support shall last until the recipient's death, the payor's death, or the recipient's remarriage. That would be a common order, which would mean it's a modifiable order with no fixed termination other than death or remarriage, but it doesn't mean that the payor couldn't come back to court and say enough is enough.
Mm-hmm.
Also, there's some law that tells us that at some point the payor doesn't have to continue to work just to pay spousal support. And right now that seems to be age 65 or whatever normal retirement date is. And so if somebody says, I don't want to pay anymore, I'm quitting work, before age 65, the court still has authority to set support based on what their income would have been had they not quit, or imputed or attributing income to the payor. Mm-hmm. But at 65, they can't order somebody to go get a job and continue to work. Doesn't mean you don't pay support, because there may still be a disparity in earnings and actual earnings after retirement because of separate property holdings or investments.
Okay. So when a divorced person remarries, how do new spouses tend to respond to spousal support obligations? So I guess we're talking about, in this case, the wife or husband of the spouse who's paying the alimony.
Okay. So the payor gets remarried,
yes,
and he's still paying to his former spouse, and now his new spouse looks at him and says, when is this going to end?
Yes.
This is really cramping my style.
I was hoping for more.
Yeah, I thought we'd stay in a 5-star hotel the next time we go to Maui. And I saw your ex-wife driving a new sports car. I don't like that. Yeah, it can cause conflict in a second or later marriage when there are still obligations to a former spouse, and the payor gets somewhat caught in the middle. Mm-hmm. If there's a modification proceeding, he or she is stuck trying to make the new spouse happy, which is a termination, but they're negotiating with the former spouse who wants as much money for as long as they can get it, and it becomes a very difficult situation, and perhaps pushes some of those cases to contested proceedings in court because of the difficulty of resolution. Sometimes disputes with former spouses cause the later marriage to fail because it can cause a lot of stress.
You get these series divorces. So what happens when the recipient spouse remarries or cohabits with somebody else?
Okay. Well, by operation of law, spousal support terminates on remarriage of the recipient. So if somebody remarries, they're supposed to disclose it and the support's over.
Mm-hmm. What about
cohabitation is a little bit different. The law says currently that when a recipient is cohabiting with a member of the opposite sex, that raises a presumption of decreased need for support. So what does that mean? It kind of shifts the burden. So if the payor establishes that the recipient of spousal support is living with their boyfriend or girlfriend in a marital type relationship, then there's a presumption that they at least have a decreased need. Now, what I've seen over the years is most judges will just cut it off and say, okay, that's enough. We're not going to order you to pay support to somebody who essentially is in a marital type relationship, but they've chosen not to get married to receive the support. So that's normally what happens. The current statute still says member of the opposite sex. I've started drafting my agreements to the extent I have settlements where we address the issue of cohabitation, and have changed it to member of the opposite sex or other adult.
Okay.
Because I expect that statute's going to change now with gay marriages.
Yes, right. Okay. Can the roles of the provider and the recipient change?
Absolutely. I've covered this a little bit, but without specifically saying that spousal support orders, unless designated by agreement of the parties as non-modifiable, are modifiable. That means anytime there's a material change in circumstances in the future, the court has the power to change the order based on the motion of either party. So, common example. So say the wife's the high earner and she's making $200,000 a year, and her husband is an electrician making $75,000 a year, and she's paying him $3,000 or $4,000 a month in spousal support, and she becomes totally disabled and can't practice medicine anymore. She would certainly, at a minimum, apply for relief, asking that she not be ordered to pay him anymore, and might ask that the husband electrician be ordered to pay spousal support to her under those circumstances. There can be other changes in circumstances, but probably the most common is loss of employment, or some serious medical condition.
Okay. Is there a role for life insurance when providing for spousal support?
Yes, it's not uncommon, particularly in negotiated agreements, to have a clause providing for life insurance, normally on the life of the payor. Payors often aren't comfortable with an ex-spouse having a life insurance policy on their life, so that it can be a difficult negotiation, but it's not uncommon to try and come up with an amount of coverage that would pay the recipient the amount they might otherwise expect to receive under the spousal support order. That isn't always easy to do, because sometimes you don't know, is this order going to last a year? Is it going to last 25 years? Which, back to the other point, we're talking about modifiability. The law permits parties to agree that spousal support can be non-modifiable. So you can take the court's power away, so the court no longer has authority, or maybe under limited circumstances, to modify support. And those orders are common because some people don't want to have that risk. The payor wants to know, I'm going to pay a particular amount for a certain amount of time. The recipient doesn't want to go back to court and fight about it again, and people will agree perhaps for a certain amount for a specific duration with an absolute termination.
Do they ever have like a cost of living clause in them or something like that?
Yeah, they could, or either increases or step downs. Sometimes you'll have an order that says it's going to be so many dollars per month now, but it's going to decrease at some specific time, often tied to when you would expect the recipient to have increased their income, or at least had a sufficient time. So say the recipient is finishing their college degree and needs to take a test and obtain a license, and that's going to take 2 or 3 years. You might set spousal support at a certain amount, and then maybe cut it in half, and then maybe reduce it to 0 at the time you'd expect they would be self-supporting.
Okay. Are there any substitutes for support?
Well, sometimes people will agree to a lump sum buyout. That's not always easy to calculate, but in some cases it's fairly susceptible to a calculation. So the way you might go about it is, if you said, okay, I think my spousal support's going to be $10,000 a month for 5 years, what is that, $600,000, and you'd reduce that to present value, maybe call it $500,000, and then you tax discount it if you're going to pay in non-taxable dollars. And so what would that be? Maybe reduce it again to $350,000 or $300,000, and then maybe reduce it again considering the risk that someone might die or remarry, and then offer a specific cash amount as a non-taxable payment in return for an agreement that the recipient, who otherwise would be the recipient, waives the right to ever seek or request spousal support, and the court's immediately divested of jurisdiction over that issue.
Okay. Mark, I want to thank you again for coming and being my guest today. This is, I think, certainly a fascinating and important topic, thought-provoking. So, folks, I hope that you found it so as well. And again, these interviews are going to be posted at Financial Insider Weekly if you want to take a little time again and study again. And again, get that advice from your own attorney. With that, we'll see you next time on Financial Insider Weekly.